Hi, my name is ChaYah Shalom, and I look like I got a little wild hairstyle going here. It's a little hot today. I'm a hairstylist. Don't look at my hair right now because it's my day off. Nevertheless, that's Karma, my little doggy. She's so cute. She's half Chihuahua and half Boston Terrier. She's got all the great qualities. She's not much of a yapper unless there's coyotes coming around. And she's got a little snout, so she's not one of those that snores. She's a great companion. I love her. Anyways, I just got off having a meeting here with Wonder Bee, and we did number 6 video. She was showing me some things of some documents that I'd like to share, and I'm gonna attempt to read it for you. Some of us need to see it for ourselves. I think it's really important to see what is it that we're looking at when someone tells us something for the first time. It's really important to know what is that backing? Like what is your backing? What's the standing behind what you're saying? So we want to basically do our own research by reading what we were just told on that 6th video. Wonder Bee was telling us about this Computer Matching and Privacy Protection Act. Now, the reason why she brought this up right here on the side is because on her American Express agreement, they mentioned the Privacy Protection Act, but it was like 1976 or something. And they only had a little tiny piece of it in there, saying something about privacy protection. We're protecting your privacy. She went further to find out that that Privacy Protection Act actually got amended. It got changed in 1988. So this is why she's going over this. Now, it's a possibility that because the age of computers came in, because I was in the military for 6 years, and that was actually my job, was typing, filing, and working on the new computer. So that was about 1986 or so. So I can see how they would need to have updated their act to include the word computer. So let me go ahead and try to read this. It's 8 pages. I did take snapshots of this and I put it on my TikTok. If you guys are on TikTok, you can look at ChaYah Shalom. It looks like it says ChaYah. It actually means life in Yah, and Shalom means peace. I really like the ancient Hebrew pictograph because we go over each little tiny letter that makes the word Shalom. And on the pictograph, it shows to destroy authority attached to chaos. That's how we get the true peace. Because sometimes in our mind, we have some chaos in there. Somebody told us something and it was wrong. And when we destroy the authority that's attached to the chaos in our head, means that we're going to learn the truth. And that truth is going to give us the true peace. Not the kind of peace like people are saying, oh, it's going to be okay. Oh, it's only going to take a couple more minutes. Bend over, stuff like that. They tell us peace and safety, but they're not delivering it. So anyways, I thought I would go over what that name means and how I appropriated it. But let's take a look at this Public Law 100-503, October 18, 1988. 102, Statute 2507. Let me move my little head. There we go. So this is Public Law 100-503, 100th Congress, an act to amend Title V of the United States Code to ensure privacy, integrity, and verification of data disclosed for computer matching to establish data integrity boards within federal agencies and for other purposes. Because we know, without a shadow of a doubt, that, people who compel us of the Social Security number, they're not really federal agencies, but they're using our federal number that was gifted to us for other purposes. Okay, so now let's see. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Section 1, short title. This act may be cited as the Computer Matching and Privacy Protection Act of 1988. Yeah, sometimes when they change and amend the names, they cite them in a different category and they move them. That's why we don't find them in the old name. But anyways, here we go. Section 2, matching agreements. So Section 552A of Title 5, United States Code, that's USC, is amended, number 1, by redesignating subsections O, P, and Q as subsections R, S, and T, respectively. 2, by asserting after subsection N the following new subsections. O, matching agreements. Number 1, no record which is contained in a system of records may be disclosed to a recipient agency. Ooh, this is good. Or non-federal agency for use in a computer matching program, except pursuant to a written agreement between the source agency and the recipient agency or non-federal agency, specifying, you know what I'm thinking in the back of my head? You know those 3 credit agencies? How, like if you missed a payment or something with a credit card or a car or whatever, how they can report you to those 3 credit agencies. Well, this is kind of saying right here that it's got to be a federal agency. And those credit, they people mislabel them as a bureau, but they're agencies. They're not bureaus, okay? They're not federal bureaus, at least to my knowledge. So this means something right here. They're talking about, hey, look, you got to have matching agreements. All 3 of you, this is where a lot of people go to those 3 credit agencies and they go, hey, look, this says December 12th. This says December 13th. That one says December 1st. Hey, they're not matching. Take it off my credit report. That's what they're using right here. But what I found interesting just now when I'm reading it, why I said, ooh, let's see right here. Let me read it again. No record, which is contained in a system of records, which that's what they got, may be disclosed to a recipient agency, like those 3 credit agencies, or non-federal agency for use in a computer matching program, except pursuant to a written agreement between the source agency and the recipient agency. So like, when you go to the car dealership and they say, hey, if you do this, we're going to report you, okay? Okay? Is that okay with you? No, it's not. So this right here is probably covering that. Anyways. Okay, so or non-federal agency, specifying A, the purpose and legal authority for conducting the program. Wait a minute. What is this program thing? What's this program thing? Program. What's that all about? Okay, B, the justification for the program, hey, and the anticipated results, including a specific estimate of any savings. Oh. C, a description of the records that will be matched, including each data element that will be used, the approximate number of records that will be matched, and the projected starting and completion dates of the matching program. Something's telling me something about this word program. Like when we sign up for a program, like, you know how like there's, what is it called? Child support? That's a program. They asked for the person's social security number, so they got a program going. I'm just saying. Okay, so what's this? D, procedures for providing individualized notice at the time of application. You know, just like the car dealership, they'll tell you, if you fail to make a payment, we're going to report you to those 3 credit agencies, right? You've seen that, right? And notice periodically thereafter as directed by the Data Integrity Board of such agencies, subject to guidance provided by the Director of the Office of Management and Budget, pursuant to subsection V. 2, number 1, applicants for and recipients of financial assistance or payments under federal benefit programs. Hey, this sounds good. Could all of the extensions of credit be programs? I think so. Okay, 2, applicants for and holders of positions as federal personnel. Are we federal personnel? I was just wondering. Are we federal personnel? Let's find out. That any information provided by such applicants, that would be us, we apply. Recipients, yeah, I'm the receiver beneficiary. Holders and individuals, which individual can also mean corporation. If you look at the dictionary, the legal dictionaries, you'll find that it means that as well, which we're all thinking, oh, it's just me, one person, but no, they can also mean corporation. May be subject to verification through matching programs. Oh, so that's interesting. I know when I got my car this last time, I had to get a special phone call because I put one of those fraud alerts on my credit report or something. So they want to make sure it's me. So they had to call me before they could go ahead and release the funds to the car dealership. Okay, so E, procedures for verifying information produced in such matching program as required by subsection P. F, procedures for the retention and timely destruction. Hey, what's that all about? Of identifiable records created by a recipient agency. You know how they say, oh yeah, we destroyed your birth certificate. Oh, we destroyed that contract. We don't have it anymore. Or non-federal agency in such matching program. G, procedures for ensuring the administrative, technical, and physical security of the records matched and the results of such programs. All right, let's see. H, prohibitions on duplication. Oh, let's look at that. Prohibitions on duplication and redisclosure of records provided by the source agency within or outside the recipient agency or the non-federal agency, except where required by law or essential to the conduct of the matching program. I, procedures governing the use by a recipient agency or non-federal agency of records provided in a matching program by a source agency, including procedures governing return of the records to the source agency or destruction of records used in such program. J, information on assessments that have been made on the accuracy of the records that will be used in such matching program. And K, that the Comptroller General may have access to all records of a recipient agency or a non-federal agency that the Comptroller General deems necessary in order to monitor or verify compliance with the agreement. 2A, a copy of each agreement entered into pursuant to paragraph 1 shall 1 be transmitted to the Committee on Governmental Affairs of the Senate and the Committee on Government Operations of the House of Representatives, and 2, be available upon request to the public. B, no such agreement shall be effective until 30 days after the date on which such a copy is transmitted pursuant to subparagraph A1. C, such an agreement shall remain in effect only for such period not to exceed 18 months as the Data Integrity Board of the agency determines is appropriate in light of the purposes and length of time necessary for the conduct of the matching program. D, within 3 months before to the expiration of such an agreement pursuant to subparagraph C, the Data Integrity Board of the agency may, without additional review, renew the matching agreement for a current ongoing matching program for not more than 1 additional year if, number 1, such program will be conducted without any change, and number 2, each party to the agreement certifies to the board in writing that the program has been conducted in compliance with the agreement. I've seen that word before. We are not in agreement. You know, when you send something and you say, I'm rescinding, we are not in agreement. But this one right here says that they can do something in writing as long as it's in compliance with the agreement. I canceled that agreement. I didn't like it. It sucked. P, verification and opportunity to contest findings. 1, in order to protect any individual whose records are used in matching programs, no receipt agency, non-federal agency, or source agency may suspend, terminate, reduce, or make a final denial of any financial assistance or payment under a federal benefit program to such individual. Oh, that's good. And look at this part. Or take other adverse action. Have you ever been denied credit? Against such individual as a result of information produced by such matching programs until an officer or employee of such agency has independently verified such information. Such independent verification may be satisfied by verification in accordance with A, the requirements of paragraph 2, and B, any additional requirements governing verification under such federal benefit program. So let's see, 2. Independent verification referred to in paragraph 1 requires independent investigation and confirmation of any information used as a basis for an adverse action against an individual, including where applicable. A, the amount of the asset or income involved, and B, whether such individual actually has or had access to such asset or income for such individual's own use. And C, the period or periods, the time, when the individual actually had such asset or income. 3, no recipient agency, non-federal agency or source agency may suspend, terminate, reduce, or make a final denial of any financial assistance or payment under a federal benefit program, wow, to any individual described in paragraph 1, or to take other adverse action against such individual as a result of information produced by a matching program. A, unless such individual has received notice from such agency containing a statement of its findings. Oh, you know how you get those letters? Like, we looked at your credit report and we're going to have to like deny you of your funds that you applied for. So right here, unless such individual has received notice from such agency containing a statement of its findings and informing the individual of the opportunity to contest such findings. So we can contest the credit report. That, you know, they'll say, well, this happened and that happened and blah, blah, blah. So that's why people are contesting their credit report so they can get their credit. So B, until the subsequent expiration of any notice period provided by the program's law or regulations, or 30 days, whichever is later. Such opportunity to contest may be satisfied by notice, hearing, and appeal rights governing such federal benefit program. Okay, and the exercise of any such rights shall not affect any rights available under this section. And 4, notwithstanding paragraph 3, an agency may take any appropriate action otherwise prohibited by such paragraph if the agency determines that the public health or public safety may be adversely affected or significantly threatened during the notice period required by such paragraph. Q, sanctions. Notwithstanding any other provision of law, no source agency may disclose any record which is contained in a system of records to a recipient agency or non-federal agency for a matching program if such source agency has reason to believe that the requirements of subsection P or any matching agreement entered into pursuant to subsection O or both are not being met by recipient agency. 2, no source agency may renew a matching agreement. A matching agreement. I've heard of that before. Like, to me, this is about a computer matching system. But when I just heard about this matching agreement, you know how sometimes when you work for some company and they go, do you want to donate to a certain charity and we'll match your donation. I was just wondering if maybe this is that, but I don't know. Maybe I think that this is regarding the computer matching, like all those agencies having the same thing written. Okay, so A, the recipient agency or non-federal agency, notice how it says non-federal, has certified that it has complied with the provisions of that agreement. And B, the source agency has no reason to believe that the certification is inaccurate. All right, section 3, notice of matching programs. Well, let's find out what this is all about here. A, notice in Federal Register, subsection E of section 552A of Title V, United States Code is amended by striking out "and" at the end of the paragraph 10. And 2, by striking out the period at the end of paragraph 11 and inserting in lieu thereof, quote, colon, semicolon, and, comma, and. 3, by adding at the end thereof the following new paragraph. So here's the new paragraph, 12. If such agency is a recipient agency or a source agency in a matching program with a non-federal agency with respect to any establishment or revision of a matching program at least 30 days prior to conducting such program, publish in the Federal Register notice of such establishment or revision. B, report to Congress and Office of Management and Budget. Subsection R of section 552A, Title V, United States Code as redesignated by section 2B1 of this act is amended to read as follows. R, report on new systems and matching programs. Each agency that proposes to establish or make a significant change in a system of records or a matching program shall provide adequate advance notice of any such proposal in duplicate to the Committee on Government Operations of the House of Representatives, the Committee on Governmental Affairs of the Senate, and the Office of the Management and Budget in order to permit an evaluation of the probable or potential effect of such proposal on the privacy or other rights of individuals. Okay, so let me see. This is section 4, Data Integrity Board, and it looks like it says contracts right here. Section 552A of Title V, United States Code, as amended by section 2B1 of this act, is amended by adding at the end thereof the following new subsection. U, Data Integrity Boards. Every agency conducting or participating in a matching program shall establish a data integrity board to oversee and coordinate among the various components of such agency the agency's implementation of this section. 2, each data integrity board shall consist of senior officials designated by the head of the agency and shall include any senior official designated by the head of the agency as responsible for implementation of this section and the Inspector General of the agency, if any. The Inspector General shall not serve as chairman of the Data Integrity Board. 3, each Data Integrity Board, A, shall review, approve, and maintain all written agreements for receipt or disclosure of agency records for matching programs to ensure compliance with subsection O and all relevant statutes, regulations, and guidelines. B, shall review all matching programs in which the agency has participated during the year, either as a source agency or recipient agency, determine compliance with applicable laws, regulations, guidelines, and agency agreements, and assess the costs and benefits of such programs. C, shall review all recurring matching programs in which the agency has participated during the year, either as a source agency or recipient agency, for continued justification for such disclosures. D, shall compile an annual report, which shall be submitted to the head of the agency and the Office of Management and Budget and made available to the public on request, describing the matching activities of the agency, including 1, matching programs in which the agency has participated as a source agency or recipient agency. 2, matching agreements proposed under subsection O that were disapproved by the board. 3, any changes in a membership or structure of the board in the preceding year. 4, the reasons for any waiver of the requirement in paragraph 4 of this section for completion and submission of a cost-benefit analysis prior to the approval of a matching program. And 5, any violations of matching agreements that have been alleged or identified and any corrective action taken. And 6, any other information required by the Director of the Office of Management and Budget to be included in such report. E, shall serve as a clearinghouse for receiving and providing information on the accuracy, completeness, and reliability of records used in matching programs. F, shall provide interpretation and guidance to agency components and personnel on the requirements of this section for matching programs. There's a semicolon there, so it keeps going. I think this is the last page. G, shall review agency record keeping and disposal policies and practices for matching programs to assure compliance with this section. And H, may review and report on any agency matching activities that are not matching programs. I'd like to know, what is this matching program actually? 4A, and except as provided in subparagraphs B and C, a data integrity board shall not approve any written agreement for a matching program unless the agency has completed and submitted to such board a cost-benefit analysis of the proposed program, and such analysis demonstrates that the program is likely to be cost-effective. B, the board may waive the requirements of subparagraph A of this paragraph if it determines in writing, in accordance with guidelines prescribed by the Director of the Office of Management and Budget, that a cost-benefit analysis is not required. And C, a cost-benefit analysis shall not be required under subparagraph A prior to the initial approval of a written agreement for a matching program that is specifically required by statute. Any subsequent written agreement for such a program shall not be approved by the Data Integrity Board unless the agency has submitted a cost-benefit analysis of the program as conducted under the preceding approval of such agreement. 5, if a matching agreement is disapproved by a data integrity board, any party to such agreement may appeal the disapproval to the Director of the Office of Management and Budget. Timely notice of the filing of such an appeal shall be provided by the Director of the Office of Management and Budget to the Committee on Governmental Affairs of the Senate and the Committee on Government Operations of the House of Representatives. Okay, and this says B, the Director of the Office of Management and Budget may approve a matching agreement notwithstanding the disapproval of a data integrity board if the director determines that 1, the matching program will be consistent with all applicable legal, regulatory, and policy requirements. 2, there is adequate evidence that the matching agreement will be cost-effective. And 3, the matching program is in the public interest. So here's C. The decision of the director to approve a matching agreement shall not take effect until 30 days after it is reported to committees described in subparagraph A. D. If the Data Integrity Board and the Director of the Office of Management and Budget disapprove a matching program proposed by the Inspector General of an agency, the Inspector General may report the disapproval to the head of the agency and to the Congress. 6, the Director of the Office of Management and Budget shall annually, during the first 3 years after the date of enactment of this subsection, and biannually thereafter, consolidate in a report to the Congress the information contained in the reports from the various data integrity boards under paragraph 3D. Such report shall include detailed information about costs and benefits of matching programs that are conducted during the period covered by such consolidated report, and shall identify each waiver granted by a data integrity board of the requirement for completion and submission of a cost-benefit analysis and the reason for granting the waiver. There's more. I'm hoping that this is the last page, please. This could be long for all I know. I don't know. 7, in the reports required by paragraph 3D and 6, agency matching activities that are not matching programs may be reported on an aggregate basis if and to the extent necessary to protect ongoing law enforcement or counterintelligence investigations. Whoa, what's that all about? I gotta take a bite of something here. Yum. I made myself some pho. My mom and I went to Las Vegas, and there was a restaurant, and it was called Pho King. So I had to have some pho. P-H-O. Okay, let me get back to this. My throat was getting dry for a second from all the reading. So section 5, definitions. Subsection A of section 552A of Title V, United States Code, is amended by striking out "and" at the end of the paragraph, 6. And 2, by striking out the period at the end of paragraph 7 and inserting in lieu thereof a semicolon. And 3, by adding at the end thereof the following new paragraphs, the term matching program. Oh, good. Maybe we'll actually know what this matching program actually is. You need to go outside, Mama? Are you good? She's so cute. She just got up from her nap. And my foot is getting really, I'm losing soup here. That tastes so good. I love it. Okay. By adding at the end there of the following new paragraphs. 8, the term matching program. A means any computerized comparison of 1, 2 or more automated systems of records or a system of records with non-federal records for the purpose of 1, establishing or verifying the eligibility of or continuing compliance with statutory and regulatory requirements by applicants for recipients or beneficiaries of, participants in, or providers of services with respect to cash, hey, or in-kind assistance, oh, or payments under federal benefit programs. Or 2, recouping payments or delinquent debts, all under such federal benefit programs. Or 2, 2 or more automated federal personnel or payroll systems of records or a system of federal personnel or payroll records with non-federal records. B, but does not include 1, matches performed to produce aggregate statistical data without any personal identifiers. 2, matches performed to support any research or statistical project, the specific data of which may not be used to make decisions concerning the rights, benefits, or privileges of specific individuals. And 3, matches performed by an agency or component thereof which performs as its principal function any activity pertaining to the enforcement of criminal laws subsequent to the initiation of a specific criminal or civil law enforcement investigation of a named person or persons for the purpose of gathering evidence against such person or persons. And 4, matches of tax information. 1, pursuant to section 6103D of the Internal Revenue Code of 1986. 2, for purposes of tax administration as defined in section 6103B4 of such code. 3, for the purpose of intercepting a tax refund due an individual under authority granted by section 464 or 1137 of the Social Security Act. You know, like when people were on a benefit program for, like, let's say child support, and then the dad or whoever didn't pay. So then they look up, you know, the Internal Revenue Code and the tax administration, and it looks like it says that they're going to intercept a tax refund that's due that person under the authority granted by this section right here of the Social Security Act. For the purpose of intercepting a tax refund due an individual under any other tax refund intercept program authorized by statute, which has been determined by the Director of the Office of Management and Budget to contain verification, notice, and hearing requirements that are substantially similar to the procedures in section 1137 of the Social Security Act. And then there's more. 5 is matches. So see, they are keeping their records, people, on the computer. Okay, so 1, using records predominantly relating to federal personnel. Hey, well, I guess if you're using the Social Security number, then you might be federal personnel, that are performed for routine administrative purposes subject to guidance provided by the Director of the Office of Management and Budget pursuant to subsection 5, or 2, conducted by an agency using only records from systems of records maintained by that agency. If the purpose of the match is not to take any adverse financial, personal, disciplinary, or other adverse action against federal personnel, or 6, matches performed for foreign counterintelligence purposes, wow, or to produce background checks for security clearances of federal personnel or federal contractor personnel. 9, the term recipient agency, here we go, we're getting into the definitions finally, means any agency or contractor thereof receiving records contained in a system of records from a source agency for use in a matching program. I like definitions, really helps. 10, the term non-federal agency means, here we go, any state or local government or agency thereof which receives records contained in a system of records from a source agency for use in a matching program. I'm really glad to see that they're giving the definitions here because they should have put these at the beginning, really. 11, the term source agency means any agency which discloses records contained in a system of records to be used in a matching program, or any state or local government or agency thereof which discloses records to be used in a matching program. Did they go over matching program? I thought that they did. But I have to back it up to look. 12, the term federal benefit program means any program administered or funded by the federal government. So you know that right there. That's the Social Security number. Right? Gotta take another bite of my fuck. Or by any agent or state on behalf of the federal government providing cash or in-kind assistance. In-kind assistance in the form of payments, grants, loans, or loan guarantees to individuals. In-kind assistance, like a grant. I like that one, grant. Did you receive any money? No, I received in-kind assistance in the form of a grant. Thank you for your gift. Okay, 13, the term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Need to go outside? Okay, let me let you. You've been good girl. We're gonna have to go on our walk. Yeah, we need a break from all this reading. You know how it goes. It gets boring up in here. Okay, so retirement program of the government of the United States, including survivor benefits. Section 6, functions of the Director of the Office of Management and Budget. Amendment, Section 552A of Title V, United States Code, is further amended by adding at the end thereof the following. Office 5, Office of Management and Budget responsibilities. The Director of the Office of Management and Budget shall, 1, develop, and after notice of an opportunity for public comment, prescribe guidelines and regulations for the use of agencies in implementing the provisions of this section, and 2, provide continuing assistance to and oversight of the implementation of this section by agencies. B, implementation guidance for amendments. The director shall, pursuant to Section 552A5 of Title V, United States Code, develop guidelines and regulations for the use of agencies in implementing the amendments made by this act not later than 8 months after the date of enactment of this act. C, boy, this thing keeps going on. Conforming amendment, Section 6 of the Privacy Act of 1974 is repealed. So here we go. You know that thing that, what was it called? Wonderbee showed us? Her American Express thing. And they put in there the Privacy Act of 1974. Well, they have to change that if they haven't already, because this says right here is repealed. They need to update their stuff because it needs to say 1988. Section 7, compilation of rules and notices. Section 552AF of Title V, United States Code, is amended by striking out annually in the last sentence and inserting biannually. Biannual. Isn't it supposed to be biannually, like every 6 months? That spelling looks wrong to me. Biannually. Biannually? I wonder what biannually means. I know what biannually means, but that looks like it's spelled wrong. Anyways, I digress. Section 8, annual report. Subsection S of Section 552A of Title V, United States Code, as redesignated by Section 2 of this Act, is amended by striking out annual in the heading of such subsection and inserting biennial. By striking out annually submit and inserting biannually submit. By striking out preceding year and inserting preceding 2 years. Oh, so biennially, biennial means every 2 years, huh? Biennial. Oh, okay. So by striking out preceding year and inserting preceding 2 years. Oh, okay. So biennial means every 2 years, huh? Interesting. 4, by striking out such year and inserting such years. Oh, okay. So it means biennial means 2 years. Okay. I get it now. Oh, okay. I get it. I'm sure the good stuff is going to happen, but my butt is getting cold. I'm up to Section 9. Let me see how much we got here. Section 9, come on, where's the good stuff? Is it ending? Yes, oh my gosh, I almost quit too soon. All right, I want to finish my soup. Okay, so here, section 9, rules of construction. Nothing in the amendments made by this act shall be construed to authorize, number 1, the establishment or maintenance by any agency of a national data bank that combines, merges, or links information on individuals, maintained in systems of records by other federal agencies. That might be big right there. 2, the direct linking of computerized systems of records maintained by federal agencies. 3, the computer matching of records, here it is, not otherwise authorized by law. Is this what she was talking about? That's big. 4, the disclosure of records for computer matching except to a federal, state, or local agency. This section 9 is big. I don't know the scope of it. My stomach is wanting to eat my food and my dog is wanting me to take her on a walk. But go over this part right here because that right there is really big. What she found right there, I have a feeling that, because it says right here, nothing in the amendments made by this act shall be construed to authorize the computer matching of records, not otherwise authorized by law. I think they're not supposed to be doing that. So I think she might be saying. In section 10, effective dates. In general, except as provided in subsection B, the amendments made by this act shall take effect 9 months after the date of enactment of this act. B, exceptions. The amendment made by sections 3B, 6, 7, and 8 of this act shall take effect upon enactment. So this was approved in 1988. Go back up there to look at sections 3B, 6, 7, and 8. Those are the ones that are supposed to take effect immediately. But right here, I think this is big. Right here, section 9, how it talked about, hey, you're not supposed to be looking at my stuff. Because I think this has got to do with the Privacy Act. Oh my gosh. That's amazing. Do you guys get it? I mean, how do I get off of here? I don't know. Let me see. Let me look. Oh my gosh, that's amazing. Section 9, we have to look at that further because what I think I just heard in glossing over what it was at the very, very end, it appeared to me that what it means is these agencies are not federal and they're not supposed to be looking in our stuff and sharing information. So that's how we're getting violated. So that's what I think is what that means. Anyways, I'm going to go take a walk now. I'm going to finish my pho. And hopefully this has helped somebody. I read it. I understood it a little bit. And if you guys understand some things, put it in the comments section. And please like, subscribe right now, please. It's not going to cost you anything. I don't charge, but it'll help me because, you know, it will help me. It'll help my channel. So thank you very much for listening, and I hope that you got something out of this.